Hello, everybody. This is Samantha from the law offices of Samantha Wolfe. We're located at 20 East 6th Street in Suite 206 in Waynesboro, Pennsylvania. And today I'm here for our monthly virtual seminar. Today we're going to be talking about financial power of attorney, so I'm excited to be able to dive into that. We do offer monthly virtual seminars that we do record and then post on our YouTube video or channel. So you're welcome to check out those YouTube videos either by going directly to YouTube and finding our channel, or you can find it through our website. Let's go ahead and get started. So we're going to share our screen on this side of things. This is a picture of our office. We do a lot of these seminars because we want to make sure that we're providing education opportunities for our clients and an opportunity to find out more about documents, estate planning in an atmosphere where maybe people will feel more comfortable. So welcome to our monthly virtual seminar. Today, we're going to do the ins and outs of the financial power of attorney. We're calling today, She Works Hard for the Money. The next couple of our seminars we did after song titles. So we want to do something fun and exciting. So we have it after a song title. So just let's dive in. First thing I want to make sure everybody understands is that the financial power of attorney is really the MVP, the most valuable player or document that we could have in our estate plan is the financial power of attorney. If you don't have a good financial power of attorney, there's a lot of financial ramifications. It can be very costly. It does mean if you either don't have a good power of attorney, meaning that you might have one that you've signed, however, it doesn't have the powers that your agent needs. And in Pennsylvania, there's some specific language that you have to have related to certain powers. So if you don't have that language, it would mean that your agent would need to petition the court to be granted those powers. Or if somebody doesn't have a financial power of attorney, it would mean that whoever would want to petition the court would have to petition to be granted those powers. So a financial power of attorney is a much more cost-efficient way to do it. A financial power of attorney usually runs a couple $100s, $250, $300, somewhere around there, where a guardianship is which is what you would have to obtain if you don't have a financial power of attorney, usually costs somewhere around $5,000, and it usually can take up to 3 months to get a guardian appointed. So there's a financial component and a timing component. So I wanted to make sure that people understood the importance of the financial power of attorney. The execution requirements for a financial power of attorney depend on when you're signing the document. So anytime that the law changes, it's whatever the law is at the time you sign it. We know that powers of attorney is the last major law change that we saw for our financial power of attorney was in 2015. So if we have powers of attorneys that were executed prior to 2015, it's still effective. It's just the set of rules that we use to determine the powers that people have are a little bit different. So I always tell people that if you want to make sure that your agent has no hassle, can do exactly what you want, the bank's not going to push back, or the financial institution isn't going to push back, then it's really helpful to have a power of attorney that's dated 2015 and after. In order for a financial institution to accept a power of attorney, there is a notice that's required on the first page by statutory law, and it's in all capital letters, and it has to be in all capital letters. And it's really designed to be a warning to your agent, and the notice says that they have to do what's in your best interest, and that's what a reasonable person would determine is in your best interest. And the easiest way that a financial institution can tell when the document was executed is by looking at the notice, because the notice has changed over the years as what's required to be in it. Like I said, we know 2015 was the last change. So anybody who signs a power of attorney post January 1 of 2015, they would have the most recent notice that a financial institution or a bank is looking for. In order for a financial power of attorney to be a valid financial power of attorney, there has to be two unrelated witnesses that see you sign your document, and it does have to be notarized. If you don't have those formalities, then your power of attorney would not be a valid financial power of attorney. So we need to make sure we have those execution requirements. Now, as far as an appointment of an agent who would you want to appoint and what are the different roles that go into it? So if I'm executing the financial power of attorney, the person who I'm appointing is called my agent. My position as the person who's creating and signing the power of attorney, I'm called the principal. So the principal executes the financial power of attorney, appointing an agent who can then take whatever action under the document that the agent is permitted to make. And you can configure this differently. So for example, my parents, there are 4 of us, 4 girls. And so my parents could decide to name one individual. If that individual can't serve, then they can name someone else. They can also name joint agents. So if they would name, for example, my sister and I, let's say they name Jess and I as the agent, they can either choose to say that we're serving together, meaning that every decision has to be joint and we have to be of one mind. That would be one way to do it. It would require both of us to sign in order for it to be effective. The other way my parents could do it is they could name Jess and I and say we can act individually or jointly, which would mean either one of us could act and it doesn't require both of the signatures. So if Jess wanted to take a certain action, she could. If I wanted to take a certain action, I could. We'd be able to serve individually or jointly. That's another way that the principal can appoint agents. If they do it individually or jointly, the benefit of that is there's a lot of flexibility. If you have multiple agents and any of them can act without the other, a lot of flexibility. The downside is that when you name them joint, if you have 2 individuals serving together, there's some checks and balances, right? Because then somebody's not doing something without having somebody else approve it. The other way you can do it is if you're naming an odd number of individuals. Let's say that my parents decide to name 3 children. They can always say if there's a disagreement, then it's a decision of the majority. And we can even go one step farther and say, well, maybe it's a decision of the majority as long as this person is in the majority. So if my parents want to name 3 of us, but they want to say that it's a majority rules as long as my sister Jess is in the majority, we can even specify that. So I always encourage clients to really think about who they would appoint. The default that we still have a lot of clients, as far as their decision of who they're appointing, their default is always their oldest child. And I'm trying to encourage clients, they know their children, they know their personalities. So it's really a better idea to appoint who they would trust, who's the trustworthy individual that they would feel comfortable serving in that position. Because normally we do recommend a durable power of attorney, which means it's effective when the agent signs it, when the principal signs it, and when the agent acknowledges it. So that way we don't need to have 2 physicians be in agreement to determine somebody's incapacity. So we always recommend a durable power of attorney. So you just want to make sure that when you're appointing those individuals, that they're people that you trust. And in our office, we typically do not recommend that the agent who you're appointing, we don't recommend that they sign the agent acknowledgement until they would actually need to serve. We do that so that that way they don't have the power before you want them to have the power, but we also do it as a protective measure to them, because in some counties, there have been cases that have come out that have said that if you sign the agent acknowledgement, then you have a fiduciary obligation to the principal. And we don't want somebody to have that fiduciary obligation prior to them actually serving. So it's a protective measure for clients, and it's also a protective measure for the agent that's being appointed. Now let's talk about how the financial power of attorney interacts with your last will and testament, because this is a common misconception that clients have. So a financial power of attorney is only effective while you're living. As soon as you pass away, any power of attorney, whether it be financial or healthcare, any power of attorney that you would have is no longer effective. So your agent wouldn't be able to use the financial power of attorney after you've passed away. The will is then what takes over, and that's where you would have to get an executor appointed under the will, and your executor can then handle your financial assets. Or if you have a trust, if you have created a trust and you've transferred assets into the trust, then it's actually the trustee who has power to handle those assets, not the agent under your financial power of attorney. So it depends if we're talking about during life and if we're talking about a trust or not. Let's talk about durable versus springing. I mentioned this a little bit before. Our preference in our office is to have a durable power of attorney, which means that it is effective when you sign it and when your agent signs the acknowledgement. A springing power of attorney is one that is not effective until some sort of event happens. So we see it a lot with military families where it says, during the time I'm deployed, this is who can act as my agent. The other way that we see springing power of attorneys is this language that I have here that I've taken from a power of attorney a client brought in. And you're going to see the first sentence says that this is during any time where the individual is disabled or incapacitated. That would be considered a springing power of attorney. The reason that I prefer not to do a springing power of attorney is because normally if it requires somebody to be incapacitated, it's going to require two physicians to be of one mind about capacity. And I recently served as an agent for a client, and the capacity versus incapacity is something that can be very fluid. One day they could have capacity, the next day they could have capacity, but then the third day they might not. And so I think that this can be a little bit confusing about when does the agent have the ability to act. So I always think that as long as you're trusting the individual you're appointing, you want it to be a durable power of attorney. The other thing too is if it does require an incapacity diagnosis, sometimes it can take a period of time in order to get that diagnosis or that determination. And you might need your agent to be paying bills or filing a Medicaid application or protecting and preserving your assets. And a durable power of attorney allows your agent to be able to act as soon as they sign that agent acknowledgement page. So that's why our office prefers the durable power of attorney. Now let's talk about what powers that your agent should have under the power of attorney document. So normally Pennsylvania has general powers, opening and closing bank accounts, selling real estate, defending in litigation matters. But then there are certain powers that in Pennsylvania your agent has to have very specific language. So we call them the hot powers. The reason we call them hot is because they're so important to your estate plan that we only want people that you would trust to handle them. So it's almost like caution. These could really affect your estate plan, like a hot stove. Don't get near it unless you know the ins and outs of the language. So let's talk a little bit about these four powers. So the first is unlimited gifting. So if in your power of attorney, if it just says the power to make gifts, but doesn't specify that it's an unlimited amount, then that means that your agent can only make a transfer of whatever the annual exclusion amount is every year. In 2024, we know that amount is $18,000. So if I draft a document that just says the ability to make gifts, but don't specify that it's unlimited in nature, then what that means is that my agent can only transfer $18,000 a year. The problem with that is let's just take an example with my parents. Let's say that my dad needs nursing home care and their house is titled in joint names, meaning both my mom and my dad's name is on it. If my dad were to go into a nursing home, the first thing I would tell my mom to do is to take my dad's name off the deed. The reason is because if my dad dies in a nursing home and he's the last spouse to die, then the nursing home has the ability to recover any benefits that they've paid under Medicaid. They can come back and recover that against the value of the house. So it's more protective to make sure that the house and the sale proceeds can go to the next generation. So the first thing I would tell my mom to do is to take my dad's name off the deed. If my dad does not have the capacity to sign the deed, then we need to have a power of attorney that allows my dad to be able to do that. And my parents do have financial power of attorneys. My dad has named my mom as his agent. So my mom could sign the deed, transferring it 100% to my mom. So meaning that she would sign on behalf of my dad, removing his name from the title. So she could do that as power of attorney as long as there was unlimited gifting powers in the document because the house is worth more than 18,000 and my dad's share of the house is worth more than 18,000. So unless the document says unlimited gifts, then my mom would not be able to sign a deed taking my dad's name off the title of the primary residence and therefore protecting the house. So I always encourage clients that as long as you're trusting or you're appointing somebody you trust, that you should have unlimited gifting powers in the document. Now, we do specify it has to be to a spouse, to a beneficiary under the will, so that way the agent can't just transfer to whomever. It has to be somebody specific. The next power is the power to create irrevocable trust. So this is another one where if the power of attorney document just gives your agent the ability to create a trust, it's a revocable trust and not an irrevocable trust. The reason that's important is if the example of my dad, if he's in a nursing home and my mom wants to try to protect assets, the only type of trust that we can protect assets against is an irrevocable trust. So if my mom wants to create that trust and then transfer assets into it, or if my parents already have an irrevocable trust and my mom wants to further fund it or transfer additional funds into the trust, she needs to have the power to create or further fund an irrevocable trust. If the document just says a trust, then my mom would not be able to transfer assets into an irrevocable trust and get the nursing home protection that she's looking for. The next power that we have to have specific language for is digital asset language, and that can be used for a variety of situations. One is if you have social media accounts or online accounts or emails, this would allow your agent access to those accounts. The second way that we deal with this is if you want your agent to be able to make online transactions, so being able to transfer funds between accounts and you want them to be able to do that online, then we have to have digital asset language. If you don't have that language, then your agent can't take any action electronically. And then finally, the beneficiary designation language. If your document does not specifically allow your agent to update beneficiary designations, then your agent would not have the ability to do that. The reason why this is important is I was dealing with a situation where we had a husband and wife was diagnosed with dementia, and husband wanted to be able to update his beneficiary designations to be a special needs trust for his wife. And the reason he wanted to do that is that way if she qualified for Medicaid, the funds that he would leave her would not jeopardize her eligibility for Medicaid. And if the husband didn't have capacity or wasn't able to update the beneficiary designations, the agent could do that as long as the document specified that the agent could update beneficiary designations. And again, we have language in there that says as long as it's to a spouse or to somebody under the will or as part of the estate plan. So that way the agent can't update the designations to be 100% themselves if that's not what the estate plan is. So that way we're able to protect. So those are the 4 hot powers that we like to have in our documents. I wanted to show you an example of a power of attorney that I see a lot. This is one where it's just a list of powers that your agent has. Sometimes they'll even be in place of the numbers. There'll be little boxes that you can go down and check what you want your agent to be able to do. The problem with this is that if you're looking at some of these powers, so for example, if you look at number 9, where it says engage in retirement plan transactions, but it doesn't specifically specify the ability to update beneficiary designations, under this document, your agent would not be able to update any retirement plan beneficiary designations, even if it's going to be for the benefit of your spouse, but we're just putting it in trust to protect that retirement benefit against the cost of care. So because it just says to engage in retirement plan transactions, your agent wouldn't be able to update beneficiary designations. Likewise, under number 14, it just gives your agent the ability to create a trust, but it doesn't say the word irrevocable. So that means that your agent would not be able to create a trust that would protect assets against long-term care costs. So that's 2 examples of why you want to have that specific language in there so that your agent can actually do what you need them to do to protect. Here's an example. I didn't pull all of the language, the full provision, but I pulled a start of it where it's talking about trust creation. So here we say to create, fund, amend, modify, revoke, or terminate a revocable or irrevocable trust. And because we actually specify irrevocable, and then it goes on to say, or make additions to an existing revocable or irrevocable trust, this would allow our agent to be able to either create an irrevocable trust or to transfer more assets to an already created irrevocable trust. Then we have gifting language. This is an example of what we use at our office for unlimited gifts. So we say to make unlimited gifts, and we specify that it's without regard to the federal annual exclusion limit, and that can be to a spouse, an issue, which means a child or grandchild, or any beneficiary named in my last will and testament, or any beneficiary named in a trust. That way we're covering anybody who could possibly be a beneficiary under your estate plan. Because it says the word unlimited, in the example where my dad would go into a nursing home and I want my mom to take his name off the deed, and my mom's going to do it as his agent, this would allow my mom to be able to sign the deed. Next set of language we're going to look at is beneficiary designation language. So here it just says to designate and change beneficiaries of such plans or arrangements, provided that such designation and changes are consistent with my known or probable wishes as otherwise expressed in my estate plan. So again, it's just allowing, whether it be a transfer on death or a pay on death beneficiary update, it would allow that to happen under this document. And then lastly, our digital asset language is just saying the agent may access, modify, control, archive, transfer, and delete my digital assets. And then it continues on to explain what type of assets we're talking about here. So if you have a power of attorney that you've already executed, I would recommend that you go back to see if we have these 4 powers in there, so that way we can make sure that you have all of the powers that your agent could possibly need or want. The other thing I wanted to tell clients about is that because the law changed in 2015, I wanted to explain why that's important. So the reason why the law changed is that there was a case, it's the Vine case in Pennsylvania. And what happened is we had husband and wife was in a coma. And while wife was in a coma, the husband, who was her agent under the financial power of attorney, went and made some retirement elections on her retirement accounts, picking certain options. Then wife came out of the coma. They decided they didn't like each other anymore and they got divorced, and the wife wanted to go back against the financial institutions and say that they should not have made the changes that husband requested. And so kind of went through some different court cases, and then what happened is the Act 95 was effective, and it became effective as of January 1st of 2015. And it said, if you follow and use this notice and these forms and have this specific language in there, then a financial institution is required to accept and utilize a financial power of attorney. And so that way, somebody who's acting on your behalf doesn't have to worry about a bank or a financial institution saying that they won't honor the decision. So it kind of alleviates liability concerns for the banks so that they can do what the agent would want. So if you have a power of attorney that was executed prior to 2015, it's worth having an attorney review it to make sure that it's up to date and compliant and has all the appropriate powers, so that way, if and when your agent needs to use the power of attorney, they can protect your assets or they can advocate for you in the best way possible without having to obtain a guardianship. Now, why do you need a power of attorney? So the most common misconception that we have is that in Pennsylvania, we no longer assume that if you're married, you like your spouse enough that you'd want them to be your agent under the power of attorney. We used to assume that. We used to assume if you were married, you must like them enough that they could act as your agent. But we don't assume that anymore. So what happens is if you don't have a financial power of attorney and somebody needs to do certain things like transfer the property into the spouse's name, then they would actually have to obtain a guardianship. On average, it takes about 3 months to obtain a guardianship, which if you look at nursing home care, and trying to protect assets, the average monthly cost of a nursing home is $11,547.69 a month. If it's going to take 3 months to get a guardianship, that means that you're risking $34,654.07. So meaning that a nursing home could pay that or attach to that before you're able to protect assets. It also means that it's not just $34,000, because remember, you have the cost of the guardianship, of hiring an attorney and obtaining a guardianship, and that can be a couple $1,000s. So you could be close to $40,000 that you're risking by not having a power of attorney in place. Oh, good. Now I'm looking at my financial power of attorney because I did want to take a couple of minutes and talk a little bit about the provisions that we had in the document. The other important thing that I think that needs to be in the power of attorney document is that just like there's a HIPAA release for healthcare power of attorneys and living wills, and the HIPAA release is saying that your agent can receive any information from the doctor or medical staff or can talk to the doctor, that type of release we typically put in the financial power of attorney as well. It's not called a HIPAA release. We just put a general financial release that says that your agent can obtain or can release any information that they may request. That way, if they need to sign any authorizations or they want to go and get a bank statement or be able to talk to your financial advisor, we have a release right in there embedded in the document. The other thing is that a lot of times our clients will have financial advisors, and so we want to make sure they have a financial power of attorney in place and that the financial advisor has a copy of that financial power of attorney in case something would happen. So I always like to make sure to have that. Now, certain financial institutions do have their own internal financial power of attorney that they require. So one of the things that we like to do as part of the estate planning is determining, will our financial power of attorney be effective, or do we need to do those internal forms with the different companies to make sure that if you become incapacitated, your agent can act. So we do have a financial release in there. The other thing that we do is that we always put the agent acknowledgement at the end of the document, but again, we don't have the agent sign it until they would be serving, and it does have to be notarized. So if at any point in time your agent needs to sign it, they can always take the original document and sign it in front of a notary. We have our clients execute 2 original financial power of attorneys. The client takes one. Our office does retain a second original financial power of attorney. That way, if your agent can't locate your original, they can always contact our office and get that original. The other thing that we do in our financial power of attorneys is we say that once the principal signs it, so for example, if I'm executing a power of attorney, once I sign it, then what we want to do is we want to revoke any previous ones. So right in our language, we say that once you sign it, it revokes any previous financial power of attorneys that you have. You just have to remember, if you change your financial power of attorney and you've given either your agent a copy of it or a financial institution, you need to make sure you go back and give them an updated one if you would change your mind and want to make changes to the document about who's your agent. The other provision that we include in our financial power of attorney is we do have something in there that says if you list an agent but you don't list any backups, that agent can always appoint a backup, because we never want you to be without a financial power of attorney. So we do have that language in there. Most people will name a primary and then at least a contingent or a successor agent. Sometimes we have people that name 3 or more, and then that way they're always ensuring that they have somebody who can serve on their behalf. And then the other thing that I wanted to mention is that we do have certain clients that have business interests. They might own a business. They might be 100% owner or just own a certain portion of it. And I always talk to clients about, do they need a separate business financial power of attorney, or is it the same person you would have handle your business and your personal finances? And if so, then we can put it all in one document. Sometimes clients have it where they want different independent individuals. And so we can do a separate business power of attorney if we would need to do that. On the first page of our financial power of attorney, we make sure that our clients understand that it is effective while you're living. As soon as you pass away, then it's no longer effective, or if you'd ever revoke it. And you can always revoke it at any point in time if you don't want the person you're appointing to serve. You can revoke it in writing. It doesn't have to be anything formally prepared by an attorney. You can do that yourself, but you typically don't want to revoke a financial power of attorney unless you're signing a new one immediately. Because again, if you don't have a power of attorney, then somebody has to petition a court in order to have the right to make those decisions. So I know this is a shorter seminar, but I wanted to, a lot of times we talk about powers of attorneys all at once, but I wanted to devote one session just about the specifics of a financial power of attorney. Next month for May, we're doing one that's called Staying Alive, and it's learning more about the mental health power of attorney, the healthcare power of attorney, and a living will. So keeping in the same theme of using song titles, we're going to do Staying Alive as our seminar for next month. It's always 12 to 1. You can text, call, email Amy, or you can always fill it out on our website as well. With that being said, Jess, let's stop sharing our screen. And I want to thank you for being part of this month's virtual seminar talking about financial power of attorneys. We always do consultations, so you're always welcome to call our office at 717-655-2676, and we'd be happy to schedule an appointment. If you have a power of attorney, want to review it, I'd be happy to look at it and tell you if any changes need to be made. Or if you don't have one, I'd be happy to walk you through the ins and outs of the power of attorney. With that being said, I'm going to say thank you. This is Samantha Wolfe with the law offices of Samantha Wolfe. Thank you so much for joining us for this month's virtual seminar.